Hi, good afternoon. My name is Christine Bridges. I'm the Associate Dean for Professional Development here at the University of Tulsa College of Law. And on behalf of Dean Levitt and the College of Law, I welcome you here today for our Faculty and Alumni Showcase speaker, which will be featuring one of our graduates, Lanesha Anderson. As you know, Ms. Anderson is a graduate from the College of Law. In addition to that, she did gain her MBA from the College of Business here at TU, and she graduated magna cum laude from St. Louis University. While she was here at the College of Law, she served as editor-in-chief for our Energy Law Journal, and her work and her dedication demonstrated to that role. It impressed the partners at K&L Gates, which is an international law firm, and so she started her law career there. Next, Ms. Anderson went on to represent two global Fortune 100 companies and one Am Law 100 law firm, which is K&L Gates. After leaving K&L Gates, she did go to Sprint Nextel, where she served as corporate counsel. The next stop on her career trajectory was at Shell Oil, where she served as senior legal counsel in Houston. And currently, Ms. Anderson is Vice President and Deputy General Counsel at ABM Industries Incorporated, which is the nation's largest integrated facility management company. She reports directly to the General Counsel and the Executive Vice President for the company and conducts legal oversight for 3 of the 4 business units there. So we are very pleased to have Ms. Anderson here with us today. She'll be presenting on the FCPA and telling us why it's not a foreign language and why every company and in-house counsel should be aware of this act. So at this time, let's welcome Ms. Anderson, and I will turn the podium over to her.
Thank you, Christine. Well, she made me sound far more impressive than I really am, but thank you all for having me. Thanks for joining me today. I got to tell you, it's a real pleasure to be back at the law school. When they asked me to come and present, I thought, well, you know, this would really be a good opportunity to see the law school. I actually did a drive around the campus, and it's been, can't believe it, but it's been 13 years since I've been back here. And man, how has things changed? I almost didn't recognize the place. There's, you know, all kinds of great new facilities, it seems, and even the law school's had a lot of changes, so it's a real pleasure, a real honor to be here today. So when Christine and Heather asked me to speak, I thought, well, you know, I'm not I've spent most of my time in-house, and I did spend some time in a law firm, but I wouldn't say that I'm necessarily an expert at one particular area of law like maybe many of you are. You go into a law firm, you develop a niche practice, and you're, you know, a patent prosecutor or toxic tort litigator, and so, you know, you develop some level of expertise in one particular area. And so I thought, well, man, what am I going to talk about? And so I kind of polled a lot of my counterparts, general counsels at other companies, and said, you know, what's really on your mind these days? What are you really focused on? What's taking a lot of your time and energy? And ironically enough, what they said was kind of the same thing that really, you know, I deal with a lot, which is compliance. And general counsels these days have a increased interest and need to make sure that their companies are in compliance with federal and state laws, but particularly certain laws, and one of them is the Foreign Court Practices Act. And I actually spend quite a bit of time on this with my company, and a number of my counterparts did as well. So I thought, well, not necessarily an expert at it, but I know enough to be dangerous. And so I thought I'd spend some time talking with you all about that. So in any case, the subject of my talk today is the FCPA is not a foreign language. And I thought really what you know, a lot of law firm lawyers and in-house counsel realize is, you know, you hear Foreign Court Practices Act and you think, well, I'm a U.S. company. My company doesn't do any work overseas. My clients don't do any international business. So the FCPA really doesn't apply to me, which is actually not true. It does apply, and so I thought, well, this would be a really good opportunity to explain and talk through how it does apply. So I don't know, I asked Christine if she knew the mix of the crowd, how many people worked at law firms, how many worked in-house. So if I could just take a poll, how many, I'm assuming most of you all are legal practitioners, work at law firms or solo practitioners, or okay, good majority. How about in-house? Okay, 4 or 5. Okay. Well, I think this actually applies to both law firm, private practice lawyers, because you advise business clients obviously as well, but also in-house. So I didn't ask, so I'm technology challenged. Okay, there we go. So that worked. Let me just walk you through what I plan to do. I'm hoping to be pretty efficient, and hopefully we can get through all of these, but if we can't, then we'll get to as much as we can. So I thought I'd start out with an introduction to the FCPA, kind of walk you through the regulation and the statute, what it is, what the consequences are, and then go into consequences of noncompliance, both for companies and for individuals, because it applies to both. And then talk a little bit about the implications for U.S. companies. As I mentioned, a lot of U.S. companies think the Foreign Corrupt Practices Act doesn't apply to them for a variety of reasons. And so I thought we'd spend some time talking about that, and then also how it applies, or what the implications are to in-house counsel and to lawyers in general. And then next, I want to spend a little bit of time talking about how to protect your company from FCPA violations. There's a lot of really good best practices out there, and particularly continuing to develop over time on how to protect your company against these violations. And part of that protection is effective compliance programs. So I wanted to spend a little bit of time, and that's where a lot of my work and energy and effort is, in developing effective compliance programs for your companies or your clients. And then there's been quite a bit of activity in the last year or so from the DOJ and the SEC, and so I thought we'd spend some time talking about some recent trends and developments that have come up. The DOJ and the SEC as recently as a few months ago has released a resource guide on the FCPA. It's a wonderful 120-page guide that if you need something to read in the evening, you can certainly pull up. So I won't, I certainly won't go through that whole thing, but I thought it'd be good for us to spend some time talking about that. And then I'll open it up to questions and discussion, and hopefully there will be some. So, I don't know, I'm a huge Dilbert fan, and I always like to start my presentations with the Dilbert, and the Elbonians are pretty famous with Dilbert. I don't know if you all have heard of those. So this is what I think is a really good illustration of corrupt payments. And so it goes, the Elbonians are demanding bribes, or else they won't do business with us. And he says, hire them as overpaid consultants and don't ask them for anything. That way, it's all legal. And by legal, you mean won't get caught? Potato, potato. So that's, I thought, a really good illustration of a clear violation of the FCPA. That one is pretty clear-cut. So let's talk about the introduction to the FCPA and why it was started, when it was started, and what the underlying purpose is. So the FCPA stands for Foreign Corrupt Practices Act. It was enacted by Congress in 1977, which was during the Nixon era. And at the time, there was a lot of corruption by companies, a lot of illegal and corrupt payments going to foreign officials trying to get business. And so Congress enacted this act to combat that. As part of that, that time period, there was a lot of erosion in the trust of the business community. And so Congress said, we really need to do something about that. And so they created the Foreign Corrupt Practices Act. And the act is designed to stop bribery of foreign officials by American companies that are doing business outside of the U.S. But you'll see as we get to it later, it really isn't just U.S. companies. The FCPA really has broad jurisdictional reach. So it applies not only U.S. companies, but foreign companies headquartered overseas, but doing business in the U.S. in some capacity. It is enforced by both the Department of Justice and the Securities Exchange Commission. They both share responsibility for enforcing it. And more increasingly, the FBI has gotten involved in a lot of alleged violations and investigations as well. So, but it's primarily the DOJ and the SEC. And as a result of this law, when it was passed in the 70s, a lot of U.S. companies came to Congress and as part of their lobbying and said, hey, listen, you've passed this law and that's great, but we're now at a competitive disadvantage as a result of it because we have companies that are in other parts of the world, they don't have these same stipulations. And so they can bribe public officials and get business as a result, and it puts them at a competitive advantage. And so as a result, the U.S. went out and started negotiating with a number of their trade partners and asking them to implement similar laws. And so now what you see is an entire scheme of international scheme, including the UN and some other organizations that have created similar anti-bribery and anti-corruption laws in their countries. About a year ago, the UK actually passed a new law, which many of you may have heard of, called the UK Bribery Act. And it is very similar to the FCPA. It actually is even more far-reaching than the FCPA is. It was enacted in 2011, and we'll talk about that briefly, even though that's not necessarily in the scope of my conversation. it is something that you should be thinking about as part of any review that you're doing for your company on anti-bribery and anti-corruption. So the two primary components of the FCPA, there's two provisions that primarily make up the FCPA statute. The first one is an anti-bribery provision, which we'll talk about, and then the second is an accounting and internal controls requirement. So we'll walk through both of those. There's also a jurisdictional reach component to it. As I mentioned, the FCPA has really far-reaching jurisdictional reach, and so we'll talk through all the companies and individuals that are potentially subject to the FCPA. And then we'll talk about some exceptions and defenses. There aren't many. There are a few narrow exceptions, and then there are a couple of defenses. So we'll walk through those, and then again, we'll talk about what the consequences are both for companies and individuals. So the first provision of the FCPA is called the anti-bribery provision. And basically what it says is that a U.S. company or person is prohibited from making any payments or offers to pay corruptly, and corruptly is not necessarily defined, for anything of value to a foreign official, either directly or indirectly, for the purpose of obtaining business. And as I'm sure you can imagine, each of these 5 elements of the provision have been heavily litigated and heavily discussed by law firms and the DOJ and the SEC. So the first one is corrupt payments, and the statute, unfortunately, does not define what corrupt is, but Congress has said it means an intent or desire to wrongfully influence the recipient and cause the recipient to misuse his official position. So I'm sure that was really helpful. So it's not really clear what that is, but what is clear is that the intent does not mean that the payment has to be made or even requested by the official. So if you offer to make a payment to an official, even if they didn't request it, and you had corrupt intent, then the act is triggered. So the other part of this is attempting to make a payment is sufficient. So you don't have to actually give the money or the payment or whatever you're giving of value to the official. Just the actual offer of it is sufficient as well to trigger the act. And I mentioned to you the SEC and the DOJ recently released a resource guide, and the one thing that the guide did talk about was that the actor does not even need to know who they're trying to give the money to. So if an executive comes to you and says, I don't care who you need to pay, just get it done, that in and of itself is also enough to trigger it. So they don't need knowledge of who the person is. So that's the first part, the corrupt payment. So the second one is anything of value. And again, this has also been heavily litigated. And anything of value, there's no de minimis threshold. It could be any amount. And as a matter of fact, a lot of the cases that you'll see on FCPA violations are a number of very minimal de minimis payments that are made over an extended period of time to foreign officials. So there is no de minimis threshold for this. Gifts, charitable contributions, tickets to a football game, any kind of payment, all considered anything of value. So you have to be very, very careful about that. Now the one good thing is the resource guide that I mentioned to you does talk about there are certain things that are permissible, right? So if you're doing business with a foreign government, for example, and you need to bring some of the senior management, you need to bring them over to the U.S. to show them what it is that you're working on, and you can show that there is a legitimate business purpose, the expenses are reasonable, and you document it, it's transparent and clear what it's for, then in those instances, you do get an exception that doesn't trigger the act. But what I tell my business clients is, it is not up to you to decide what is reasonable. It is not up to you to decide to make the judgment call. That's what I'm here for. So I would certainly suggest that if you are doing business with a foreign government, they are a customer, that you have your business clients come to you every time they want to spend money, even if it's just lunch or coffee. Have them come to you and let you kind of walk them through that. So that's anything of value. Directly or indirectly. This is another thing that's really hotly litigated. A lot of the most recent cases are with companies that have violated the FCPA because of their interactions or relationships with third parties. So your company doesn't actually have to be the one making the corrupt payment. If they are engaging in business with a third party and that third party makes a corrupt payment, you are liable. If they make it on your behalf, you are liable. Your company is liable for that. So you don't get off the hook just because you can say, well, I didn't make the payment or my company didn't make the payment. If you have a third party that you're doing business with, and that could be a distributor, a reseller, a joint venture partner, a franchisee, a subcontractor. It's pretty broad what a third party is included in, and we'll talk a little bit more about that as well. But that's really a hotly contested issue right now. So directly or indirectly. And then the last one is for the purpose of obtaining or retaining business. So the payment has to be, the corrupt payment that has to be made for the purpose of trying to influence a decision. So if you're up for a bid and you are trying to win a bid and you give a gift to a foreign official, you're doing that to induce them to give you work. Or if you are part of a procurement process and that procurement process, you take somebody out or you give them cash under the table. It has to be for the purpose of getting business. And then the last piece of it is there are criminal penalties that you could actually be subject to if it's shown that the violation was done willfully. So this is the jurisdictional reach that I had mentioned to you. I mentioned that it's pretty broad reach, and so it covers pretty much any company that you can think of in the U.S. So the first one is any company organized under the laws of a state in the U.S. So obviously any company that's headquartered in the U.S. subject to the FCPA. But it also includes foreign companies, companies headquartered outside the U.S., but doing substantial business in the U.S. So may not be headquartered here, but you've got a significant office, or you've got, several employees here, or you ship to the U.S. You may not have actual operations, but you're doing business in the U.S., you're still subject to it. There's also this concept of issuer. So any company that files periodic reports with the Securities Exchange Commission, and this is what gets a lot of foreign companies. If your company is headquartered in Switzerland, but is on the New York Stock Exchange and trades securities, then that company is still subject to the FCPA. And then any company with the principal place of business in the U.S., so even if there aren't substantial operations, but you have an office here, then you are subject to it. And then, of course, any U.S. citizens. Now, what's not covered under here is a company that has no operations here, doesn't trade here, but could still potentially be subject to the FCPA. And there's actually a recent case called the Panalpina case that happened a couple years ago. It was a Switzerland-based company, and they were not publicly traded in the U.S., had no operations in the U.S., but they were doing business with companies that were either headquartered in the U.S. or had stock traded in the U.S. And as a result, and they had alleged corrupt payments in Nigeria, and they said, wait a minute, we're not subject to the FCPA. We're a Switzerland company. We don't trade in the U.S. We have no operations in the U.S. We're not subject to it. And the SEC said, hold on, you are, because you caused these other companies who you knew were subject to the FCPA to violate it. And so as a result, you're now also liable. And as a result, they got slapped with a pretty hefty penalty and a disgorgement of all their profits from that contract, or those series of contracts as a result of it. So pretty steep penalties for a company that really didn't even think they were subject to it to begin with. And I guess I should have mentioned, we'll take questions at the end, but if someone has a burning desire for a question now, please feel free to raise your hand and stop me. So the next provision is the FCPA accounting requirements. And where the first anti-bribery provision applies to issuers and U.S. companies, this accounting requirement only applies to publicly traded companies. It does not apply to a privately held company. And this one requires that a company that's publicly traded, that's an issuer, keep their books and records in reasonable detail, and that they accurately and fairly reflect the transactions and dispositions of assets. And basically what this is saying is that if you're a publicly traded company, you have to maintain adequate internal controls that provide a way for you to detect and deter corrupt payments. And if you're a publicly traded company, hopefully, chances are you've got internal accounting controls anyway because of SOX and a number of other things. but the FCPA does have this additional requirement that you do that. It also requires that you perform audits at reasonable intervals. So most publicly held companies have an internal audit function, and also obviously have external auditors as part of being publicly traded. So this is not something that is should be too difficult to meet, but it does require that. And there is criminal liability for knowingly falsifying books and records or failing to implement internal accounting controls. And this is where you see the really hefty fees and even the sentencing of prison time is in this accounting requirement. This is where a lot of companies get caught up. They can show that they actually did not have intent to make a corrupt payment, but again, through third parties, the SEC will come in and say, you should have known that these payments were being made. You've got all these records of payments being made, and you didn't detect it and you didn't report it. So the exceptions and defenses, there's really not a lot of exceptions and defenses to the FCPA, but there are a few. And the first one is called facilitating payments. And what the FCPA does say that these may be permissible. I would caution you here. So a facilitating payment is also what we call a grease payment. I've got 50 employees that are going into Dubai, and I want to get them in there quickly because we've got this huge project that we're working on. And so I'm going to pay the customs office, the immigration office, to quickly get their visas done. That would be a facilitating payment. That is potentially permissible under the FCPA. The caution here is most companies, including mine and probably yours as well, have policies, their compliance policies that prohibit these payments. And if that's the case, then obviously whether or not it is permissible under the FCPA is irrelevant. So that is a narrow exception to the FCPA. Now, an affirmative defense is if it was permitted under local law. So if you can find a local law that says corrupt payments are permissible in our country, and it's in writing, then you don't have to comply with the FCPA. Unfortunately, as many of you know, even if corrupt payments are, kind of the tradition or the culture there, you're not likely going to see it in writing. And even places like Nigeria and some really, kind of countries that are more known for high corruption, they do not have anything in writing that says thou are allowed to make corrupt payments to our foreign officials. So I would say even though it's an exception, it's not really an exception. And then the last one is a defense is available for a bona fide expenditure related to promotion of goods or services. So if your company is in Singapore and you go over to Singapore for a trade show and you have little trinkets that you're giving out to everyone, and as a result a foreign official comes up and gets one of the trinkets, obviously that's a bona fide expense, not triggered the FCPA. Now the fun part, consequences. And I always love this part of my presentation when I'm talking about business clients because, before that they're like, blah, blah, blah. And then you say, well, wait a minute, there's actual consequences. And then you say, well, it's not just for the company. There are individual consequences. Then they perk up. So consequences for companies. So obviously fines. There are criminal fines and administrative fines that a company can incur as a result of noncompliance. They can also disgorge profits. So all the profits that you made under that particular contract, they can actually take those back. And that was the case with the Panalpina case. One of the really big consequences that is taking effect now, particularly in the world of social media, is reputation damage. And I'm sure many of you have seen in the newspaper lately some very large companies, and I won't name any of them, but have taken huge damage to their reputation, and as a result, erosion in their share price as a result of allegations of noncompliance with the FCPA. Suspension or disbarment. So for companies that do business with the U.S. government, large government contractors could potentially be suspended from bidding or working on any other federal government contracts as a result, or disbarred completely. So that's, for someone that's a government contractor, that's a significant stick for making sure that you comply. And then corporate monitors. So the SEC and the DOJ can come in and say, we require you to hire a third-party person or group of persons to come into your company for a number of years and basically make sure that you are complying going forward. Now for individuals, there are also criminal fines and civil fines that you can actually get individually but then there's also potential jail time, and that's the part that I make sure that I focus on with my business clients. We will not just have to pay a fine as a company, but you could potentially go to jail if you do not comply with this statute. Now, the largest settlement, I put this up because I think it crystallizes for you kind of the potential damage that a company can have. The largest settlement today was with Siemens, which again was a German company, not a U.S. company, but still subject to the FCPA. They paid $1.7 billion in bribes to Iraqi officials over an extended period of time, and they got slapped with an $800 million fine and was forced to hire a monitor, a third-party monitor, for 4 years. So, pretty substantial stuff. So this just shows the trend of the sanctions that the DOJ and the SEC have assessed on FCPA violations from 2007. So you'll see in 2010, it spiked pretty significantly, and then it's tailed off in 2011. Now, what I really find interesting is the numbers for 2012 have not come out yet. So I'd be interested to see if that trend is going to continue downward. But I do think that part of what we're seeing here is companies are starting to really get educated and get smart about this FCPA. They're starting to bring in experts, starting to get outside help, and really beef up their compliance programs as a result of 2010 and a lot of damage that companies have incurred as a result of this. So more to come on 2012 to see if that's really the case. But you'll see in 2010, $1.8 billion total in fines assessed across all the companies for fines. Now this chart shows kind of a similar trajectory for the number of enforcement actions. And again, you'll see 2009, upward trend, 2010. DOJ was much more active in 08, 09, and 2010. And now you actually see the flip side where the SEC has been more active than the DOJ. And I think part of it is this SEC has been under, as you know, a lot more scrutiny in cracking down on companies for corruption and failing to comply with all the SEC regulations. So they've actually started to pick up activity. They've hired more enforcers. They've hired more people in their departments to go after companies for these sorts of violations. So again, we'll kind of see how this pans out over time. But 2010, definitely a big year for FCPA enforcement actions. Sure.
Where do those fine dollars go? They don't just go into the U.S. Treasury, do they? They go to DOJ?
They go to DOJ or SEC, absolutely. And I suspect, and I don't know this to be true, but I suspect that probably goes back into their budget to hire more, to grow the department or to continue doing other enforcement actions. But I don't know that for sure. That's my speculation. So, my company, my client, does not operate in foreign jurisdictions. Why do I care about the FCPA? It's only for companies that work outside the U.S., right? No. So here are some of the implications for U.S. companies and their counsel. So the first one we talked about earlier, it applies to U.S. companies. And there's no revenue threshold or number of employee threshold. You could be a 5-person, family-owned, privately held business, and you are still subject to the FCPA. So there is no size threshold, unfortunately. It applies to public and private companies. So it doesn't, at least the anti-bribery provisions applies to both public and private companies. So my company doesn't operate outside the U.S. We're purely domestic. Why should I be concerned? Well, the first way that I think a lot of U.S. companies get into trouble is M&A activity. So if you've got a company that does quite a bit of acquisition and you're looking at targets and those targets do any work at all internationally, then you could potentially be buying a successor liability for the company that you're acquiring in, right? So you buy a company and they have a distributor relationship with an international firm, or they sell online to China, or they ship goods in from China. All of those companies would be subject to the FCPA. So you have to really watch M&A. And unfortunately, the way the law is structured, there is a successor liability. So if you buy a company and they had some sort of corrupt payments or issues before you bought them pre-acquisition, you inherit that liability. You cannot get off the hook for that. So the next way is through your joint venture partners or your distributors or resellers. My company doesn't do business outside the U.S., but there was this really cool deal where we entered into a joint venture and they do business internationally. Well, you're still subject. There is provisions that allows the DOJ and the SEC to come after principals and shareholders of joint ventures. If you've got a joint venture that's out doing work or business internationally, even though you're not operating the joint venture, you don't have any management as part of the joint venture, you are still subject to the FCPA. International business through any other third party. So you have franchises set up, or you buy from companies in China, or you resell to a company that sells in Singapore. You're still subject to the FCPA and the actions of those companies as well. And then finally, global expansion. I mean, what company is not looking to go overseas in some capacity, right? Every company is looking at growth opportunities. And, you know, as the U.S. market starts to get saturated, a lot of companies are looking at global expansion. And so while your company may not be subject to the FCPA today, as they're part of the strategy, if your company is looking at opportunities to go globally, you should always keep the FCPA in the back of your mind as a result of it. So we've talked about how we think the company is subject to the FCPA, even though we're a domestic company, or maybe we do have international operations, or we do have third parties that are involved in international operations on our behalf. How do you protect yourself against FCPA violations? So there's obviously a number of ways, and we'll go into some of these in more detail, but the first one is develop effective compliance programs. And I want to make sure that I get this quote right, even though I should know it, by Benjamin Franklin. An ounce of prevention is worth a pound of cure, and that is never more true than when you're dealing with the FCPA. If you can develop programs and policies on the front end to prevent and deter violations of this law, you're far better off than having to do investigations and self-report and fix things on the back end. So that's far and above. If I can give you any advice today, develop really effective compliance programs for your company or for your clients, or make sure that they have them in place. Know who you're in bed with. So as I mentioned, there are tons of examples out there of companies who have gotten themselves in trouble because they're in bed with third-party agents that are doing things they shouldn't be doing, and they have no visibility to it. So the way to prevent that is to do your due diligence. So we have a process at our company where every single subcontractor, distributor, franchisee, joint venture partner has to go through a robust vetting process. And that includes, we need to see your financials. We want to know what other U.S. companies you've worked with. We want references. We want to know if you have anybody employed that is a foreign official, or anybody that's employed that has a family relationship with a foreign official. If they are, we want to know why they're qualified to work at your company. So we don't want the daughter of the sheikh working at your company just because she's a daughter of the sheikh. We want her working there because she's qualified to do or perform whatever services that she was brought on to do. So we are very diligent, and I would suggest for your companies be very diligent about doing your due diligence on these companies before you sign up to interact with them or do business with them. And then also require FCPA contracting language. So once you've done your due diligence on them, require them to sign a contract that includes robust, thorough FCPA language. And that would include things like a certification that says they understand the FCPA, they know what it is, that they agree to comply with it, they agree to allow us to audit for it, that they will cooperate with an audit, that we can terminate the contract at any time if we believe that there are any wrongdoings as it relates to the FCPA, and that they will indemnify you. So if you get either a civil suit or a criminal suit from the DOJ or the SEC for an FCPA violation as a result of something they've done, they will indemnify you, and they will pay the fines, and they will help you pay your legal expenses as a result of it. The next one is know the red flags. So you see something that comes across your desk, and it's, well, we needed to make this payment to this company because they're a consultant. Well, what do? Well, it's not really clear what they do, but everyone has to do it in this country. So that's a red flag. Or they work in Afghanistan, but we pay them in Iraqi dollars, and the money goes to Nigeria. Red flag. So, really educate yourself on what the red flags are that says, something doesn't smell right here. If it doesn't smell right, something's probably wrong. That's really critical. And train your accounting professionals to know what the red flags are, because they're actually going to see it before you do, right? They're going to see these really mysterious payments coming through that don't quite look right. And they're, bookkeeping fees or consulting fees or, custom expediting fees. And they're going to see it. And if you train them to know what the red flags are, they can really help you point those out. And that goes to the next point, train at all levels. So develop training for your personnel, for your staff, and require all levels in the organization to take the training. So starting with your board of directors, because the tone at the top is really important, right? All senior management, anybody in accounting, anybody that does sales internationally or could potentially do sales internationally, anybody that's in business development, marketing, obviously your lawyers, but provide training and make people take the training at least annually, if not more, depending on what their roles are. And that, again, prevention is the best way. Develop communication protocols. So, and that's really a two-pronged approach. The first one is have a way for employees to report bad actors or bad conduct. And it should not be through their management channel. It should be some way that they can report out confidentially without the fear of retaliation or repercussions from their management as a result of it. So if you have an internal audit function or you have a compliance function, those are really good places to report in. But if not, then maybe create somebody within the legal department or your primary outside counsel. But have a way for people to make a phone call and report bad activity without the fear of retaliation. So that's really the first approach on developing a communication protocol. But the second piece, and a lot of people actually miss this, is develop a communication protocol for escalating up through your management. So if you become aware of an issue, there should be a way for you to get that issue in front of your CEO and your CFO and your board of directors. When I was a very young lawyer, one of the lawyers that spent a lot of time with me, training me, always said, you never want your client to be surprised. And I've carried that with me through my career. No surprises. So the last thing you want is for your board, heaven forbid, to hear in the newspaper that there's some alleged violation at the company. So you always want to have some kind of protocol for, escalating it up through your management. Don't let the pigeon drive the bus. So I don't know how many of you all have kids. There's a book out there. I have a 7-year-old daughter, and one of her favorite books is Don't Let the Pigeon Drive the Bus. Anybody heard that book? Or is it just me? Okay. So it's a Caldecott book. It's a storybook. And so the story goes something like this. There's a bus driver, and he's talking to the readers of the book. And he says, I'm the bus driver of this bus, and I have to leave for a little bit. And there's this pigeon over here that really wants to drive the bus. He is not allowed to drive the bus. Whatever you do while I'm gone, I'm leaving it up to you. It's your responsibility. Don't let the pigeon drive the bus. And so next page, the pigeon comes up and, oh man, I'm so glad he's gone. I really want to drive the bus. I've been waiting on him to leave. Will you let me drive the bus? And, of course, my 7-year-old, no. So then the rest of, several pages of, I'll be good. I'll be a great driver. I promise I won't tell anyone. I'll give you candy. All kinds of stuff. I really want to drive the bus. And every time that he asks, can I drive the bus? No. So bus driver comes back and says, I'm back. Thank you so much. Did you let the pigeon drive the bus? Absolutely not. He says, good, great job, applause, you did a fabulous job. Well, that same philosophy applies here. We represent our business clients, but we also represent the company. And you could develop the world's best compliance program there is. You could do all the due diligence. You could know the red flags. You could provide training. And ultimately, as you know, there inevitably will be or could be someone that wants to do the wrong thing. They want to do something that's forbidden. And our job is to not let the pigeon drive the bus. To just make sure that we continue to say, no, that is against the law, that is a bad act, and I have to protect the company's interest. And it will not make you popular. It will not make the business clients like you, but it is our role, obviously, to make sure the pigeon doesn't drive the bus. And then finally, if you know, once you know, you disclose and remediate. So there's a whole host of companies that once they found out, they self-reported. You self-report, you say, we found out about it. As soon as we found out about it, We reported it, and now we're doing a thorough internal investigation, and we're doing everything we can to fix the problem. On the flip side, there have been companies that have decided not to do that, not to self-report, and as a result, they get dinged much more significantly when a settlement is reached or when they have finally gotten it prosecuted than if you actually come forward when you know about it. So we talked about, the best way to avoid violations is to create an effective compliance program. Well, here's some of the hallmarks, and because we're kind of running short on time, so I'm going to kind of go through these pretty quickly. Hallmarks of an effective compliance program: a risk-based approach to compliance. So the DOJ and SEC, as I mentioned, released this resource guide, and one of the things they talked about is a one-size-fit-all compliance program is not a compliance program. You have to look at your business, you have to look at your industry and say, here are the things that are important to my business, here are the ways that we are potentially exposed. We need to design a program that fits that, our particular needs. So you have to really tailor it to your business and your industry. So the way to do that is to conduct a risk assessment. Go out to your business and talk to them. What are we doing internationally? What do we want to be doing internationally? What kind of third parties do we have? What kind of relationships are they? How could they potentially get us in trouble? And really listen to what it is that they have to say. And then when you're creating the policies, develop policies for that. So I'll give you an example. As I mentioned to you, we do a very thorough investigation of our third parties. Well, that is as a result because we have a large franchising business, and our franchising business has international franchises. And so as you're starting to get to learn the business, you say, okay, well, if we've got people that are reselling our products or reselling our services under our brand in international jurisdictions, we really need to make sure that we know and understand their business. So a large part of our compliance program is designed around vetting third parties. Now, you may have a company that does all of its business direct and doesn't really do a lot of business with third parties, but you may have an acquisitive company that does a lot of M&A internationally. And so you should think about developing a compliance program that's more M&A specific. How do I do due diligence on these companies? How do I integrate them into the company? How do I make sure that the new division has training for the employees? So you really have to think about what the specific needs of your business are and develop a program around that. Tone at the top. There is nothing more important to an effective compliance program than the business people knowing that the CEO and the CFO and the senior management buy into it. They believe in it. I've even talked to CEOs who said they keep their code of conduct on their desk, and they make sure that people see that it's on their desk. They may not actually look at it every day, but it really sends the message to people when they come in their office. Compliance is important to this company, and it's important to senior management. And so if it's important to me, then it should be important to you. So tone at the top is really important. When we do our training, we have the CEO and the presidents of our business units send out the email that says, I know you really want to take this training. I know you've been looking forward to it. And this is really important to me, Mr. or Mrs. CEO. And so I'm asking you for you to take the training. And that makes a world of a difference when people are getting that message from the top. And then have a code of conduct. I think most companies are far enough along where they're actually doing that already. But have a code of conduct that talks about the values of the company, what's important, what you don't allow, what's important to you, and then develop policies. So not only an anti-bribery, anti-corruption policy, but an antitrust policy, a travel and gifts and entertainment policy. But develop a scheme of policies that are applicable to your company. Ongoing training. I think I mentioned this earlier. Your board of directors, it should start there. Have your board take whatever anti-bribery, anti-corruption training that you do, or FCPA training, have them take it. All of your employees, have them take it. Have them take a test. I've actually seen a number of my clients that did not pass the test, which was troubling. And so then you say, okay, well, you have to go back and retake it. I need to make sure that you understand this. But also your partners, so your franchisees, your distributors, your resellers, your subcontractors, have them take training. And some of them may say, well, I already have my own training. Then you say, okay, that's great. I'd like to see that. And you make sure their training is adequate, and you make sure that they are having the relevant employees within their organization take the training as well. Third-party due diligence. Vetting and certifying any third-party agents. So any company that can hire on your behalf outside the U.S., they can get visas. Anyone that's doing customs for you, so if you're shipping goods into another country, Nigeria is a very good example. You hear people say, well, if you want to get your goods out of customs in Nigeria, you have to pay. So if you have any, I think they call them procurement agents or supply chain managers, if you have some of those in some of the more corrupt countries, you should really watch and make sure that they're not doing some of these underhanded payments, because there are a lot of cases where that's been happening. But also M&A targets, and I had mentioned that earlier. There is successor liability for companies that buy international firms or firms that have operations internationally, and they engaged in bad actions before the acquisition. You inherit that liability. So you should do your due diligence on them before you actually buy them to make sure that you're comfortable with it. And then have a reporting mechanism, a chief compliance officer or a compliance department. When I worked at Shell, believe it or not, there was over 50 compliance professionals in the organization. There may even be more now. Obviously, every company is not, $500 billion company, and so you may or may not be able to have a compliance department that's large. But you can have one person, and if there's no in-house department, you could have, a law firm that does a lot of your work to be the reporting mechanism. But have a way for people to report violations or potential violations, and make sure that it's confidential. Make sure that it's accessible. So, you can have an online portal of some sort, or a way to send an email to a compliance officer. That works as well. And then continually review the policies. We review ours annually. You don't have to do them annually. You could do it quarterly or something else, but I would suggest at least annually. And then anytime there's new legislation or there's a significant case that comes out or some new regulation, you should always review your policies then and refresh as a result of that. Okay, enforcement trends. So the DOJ and the SEC have gotten pretty creative here lately in enforcing the FCPA. And so I thought we'd spend a little bit of time kind of going over what some of those trends are so that you know what to watch for. So investigations are becoming far more political. Everybody's trying to get in the media as I found the big bad company that did something wrong. And so you've got to watch the reasoning for how they're finding investigations. And then the SEC is under more scrutiny. They've gotten some pretty bad coverage themselves, and as a result, they don't want to miss anything. So they're hiring more people. They're less interested in closing out a case. They just kind of let things linger because they're afraid they're going to miss something. Well, if I close this case, I may find out tomorrow there was some other things going on. So they really are under more scrutiny, and so they are, as a result, being much more cautious about their investigations. Another trend that we found is that cooperation helps. So they have they're using more deferred prosecution agreements. Well, if you cooperate with me, we won't prosecute. If you follow this regimen and you do all these different things over 3 years and you report out to us in those 3 years, then we won't prosecute. Now, if you don't do those things, then we reserve the right to come back. But if not, then you'll be off the hook. And so those have been really popular with companies that particularly government contractors that don't want to be disbarred. So if you're prosecuted, then potentially you can be disbarred from getting government contracts. There's also more interest in going the administrative route instead of federal court. ALJs now have the ability to assess fines, and I guess they didn't before, but they do now. And so as a result, you'll see the agencies having more interest in going through an administrative proceeding than going through the federal court. And then there's enhanced enforcement tactics. It's kind of like the CIA. They got wiretaps now and all kinds of interesting ways to figure out what's going on, and forensic IT systems where they can go into emails and find stuff. So they really are kind of beefing up their enforcement tactics and really not just being straightforward, but really going after companies to try to find when things are going wrong. And then an increase in criminal proceedings. You're finding more executives that are actually serving prison time as a result of it. And that's not something that was happening before, but it's certainly happening more now. Another trend is that they're focusing on specific issues. So that Panalpina case that I mentioned to you, Panalpina was a supply chain manager, and they were helping companies get goods into Nigeria, mostly oil and gas companies. And they were paying Nigerian foreign officials under the table to get their goods out of customs. So you'll see quite a bit of that activity going on. The current Walmart investigation that's going on, many of you may have heard about that. Walmart has had some allegations lately of some of their permitting and construction work in Mexico. There's some allegations that they made payments to, or their agents made payments to get construction bids in Mexico. So you'll see a renewed focus or a focus on immigration and customs. And then there's more interest in specific high-risk jurisdictions. So there's a thing called the Corruption Perception Index, and I think it's Transparency International that puts it out. But it's a list of all the countries, and there's an index from 1 to 10. And actually, it's the exact opposite. So 1 is the most corrupt countries, and 10 is the least corrupt countries. And so you'll see countries like Nigeria, Brazil, that are more corrupt than countries like Canada. And that's something really good for you when you're looking at, and your business is looking at expanding into certain countries. I would pull that index up and get a sense of what the Corruption Perception Index is for that, so that you can understand what the potential risk is. But obviously Mexico, I mentioned Nigeria, and also China. There's quite a bit of activity going on in China as well. And then lastly, a focus on new whistleblower provisions in Dodd-Frank. So Dodd-Frank, as you all know, came out in 2011, but there's actually a new section, or a section in there, 922, that gives rewards to whistleblowers. And it's fairly easy to become a whistleblower under this. It's for any person that provides original information to the SEC about potential violations of any SEC-regulated law. So it's not just FCPA, but because the SEC enforces the FCPA, that is one of the laws that a whistleblower would be potentially protected under. So they make reporting easy. You literally go on a website and you fill out a page on the website. They've even got drop-down menus. Which law do you think your company violated? And here is the list. Oh, I didn't even know about that one. Let me check that one too. So they make it pretty easy for you to report. There is no initial reporting to your company, which is, from putting my company hat on, which is slightly unfortunate, because you could develop all these compliance programs and reporting mechanisms, and then people don't even have to use them. They can literally just go right to the SEC and say, there was a bad act, and then of course you know nothing about it. So there is no initial reporting requirement. And then the SEC has pretty broad discretion on the range of the reward, 10 to 30% of whatever is settled. So if you got $1 million settlement, the potential whistleblower would get 10 to 30% of that. So there's a lot of incentive for people to go right to the SEC to become a whistleblower than to go to the company, unfortunately. And then they found that there's significant early results. So in the first 2 months, the SEC received 334 whistleblower tips, and 13 of those are related to the FCPA. And they actually gave their first award in August of 2012. So really quickly, considerations for compliance with Dodd-Frank. So there's a couple of things that you should be thinking about as part of your FCPA compliance program. You should consider developing a special whistleblower policy just for this. What happens if you get a whistleblower? How you should treat that person. Policy should have a process in place to make sure they're not retaliated against and protected in some sort of way. So definitely consider a whistleblower policy. And then provide incentives to employees. So they're going to get an incentive if they go to the SEC, right? You don't want them to go directly to the SEC. You want them to come to you instead. So one of the suggestions has been, give your own incentive. Say, well, if you come to us first and you allow us to try to fix it or give us a time period to fix it, we'll incentivize you somehow. And that could be either monetary or some other sort of reward. But then also advertise your company policies. Let people know, look, you don't have to go to the SEC. You can actually come to us. We have a policy in place. We have a way for you to report these types of bad acts and bad behaviors, and you will be protected if you come to us. You won't be punished as a result of this. Make reporting easy. So just like the SEC has their wonderful little website where you can go on and you can do the drop-down menu, you should make your reporting easy as well, where they can go into a portal, they can send an email, and make the reporting to the company just as easy as it is to go outside the organization. Consider composition of your compliance committee. So if you don't have a compliance committee within your company, it is a really good idea to have one. And compliance committee not only should consist of lawyers, but also business people and operations people, people that bring revenue into the company, that understand the business needs and can really get buy-in from those people as part of your program. And then spotlight and advertise good outcomes. Ask your CEO to give a yearly award for a compliance hero, or send out a newsletter applauding certain people that have done really good things from a compliance perspective. You'd be surprised at how much runway you can get out of things like just recognizing people for doing the right thing. And then finally, ensure there's speed and good protocols for an internal investigation process. So the SEC has a 120-day window in which if a whistleblower comes forward, to the company, you have 120 days in which to investigate it and report out. So you really have to make sure that you're being efficient in going through an investigation. And as many of you know, an internal investigation, if it's substantial enough, really can take quite a bit of time. So if you develop this process on the front end, it really saves you from running afoul of those deadlines. And finally, here's a couple of resources that are good for FCPA. The first one really is almost I get it every day if you subscribe to it. It's almost just something light that you can read and hear about all the people that have gotten themselves in trouble with it. And so every day I get something that says somebody did something in China. You're like, oh, somebody else did it again. And then the resource guide that I mentioned, the 120-page guide, can be found at the website on the second one. And then the ACC, for those that are in-house and have a membership at ACC, they have great policies and programs and documentation for you. So if you're starting from scratch and you have nothing, the ACC actually has standard FCPA contracting language. They have a template compliance program. They've got a due diligence checklist for M&A. They have a wealth of resources on the website, so I always refer people out to the ACC if you're really starting from scratch. And that's it. Questions? I know that was a mouthful in 55 minutes, right? Yes.
The audit or something, I would suspect that unexplained expenditures, as far as the tip-off, unexplained, because I assume most companies are greedy and they want to write off this craft rather than not be able to expense it. So right. They get pretty anything. But is there certain, and what trips people up? Where is the SEC finding out about it, or?
Yeah, well, you usually find, so that's a great question. People love email. They really do. And so there's this inclination to put everything in an email. And so you would think that because people really know that they're doing something they shouldn't be doing, they wouldn't be inclined to put something in email. You'd be amazed. They really do. So that's one way. And then the whistleblower provisions have really made a difference. And even before Dodd-Frank, there was other whistleblower provisions out there. And people were finding out about it, and companies, unfortunately, weren't taken to heart when they would get tips. And so employees or vendors or third-party agents would see this activity and they'd report it. Or they just send a tip in, or they'd make a phone call. And once the SEC or the DOJ gets a tip, then they can start investigating. And then the other way is actually a lot of our profession, lawyers, find out about it. And you're sitting in a meeting and somebody says, oh yeah, they kind of let it slip. So you've got a lot of lawyers that find out about it, or internal audit. They're just as popular in companies, by the way, as lawyers are. They find out about it and they start digging into it, and then they self-report.
Do companies ever, quote, tell on other companies? Otherwise, they know they're doing it and they're not doing it.
Absolutely.
They're losing out, so they are going to blow the whistle.
Absolutely. Yes, that happens quite a bit. So if I'm in trouble and I'm doing business in a country and I know Joe Blow's company is doing the same thing, I might let it slip. Yeah, absolutely. So you definitely got to watch competitors. So if your competitors are getting dinged for something, one, it should be a red flag for you. If you're doing the exact same activity in the exact same jurisdiction, hopefully your people are much better than theirs, and so you won't have that issue. If you find that out, then you should immediately start, probing inside your own organization.
Does
Yep.
self-reporting avoid criminal sanctions?
Sometimes, not all the time. If you can still show, now, if you have somebody that's made the payment, they did it willfully, and then they go and self-report, it doesn't necessarily help you. But there have been instances, yes, where if you self-report and somebody within the organization was doing it and the company as a whole self-reported, then yes, you can certainly minimize the chances of being prosecuted criminally. Or, as I mentioned earlier, doing a deferred prosecution agreement of some sort. Yes?
I want to ask you about the conflicts with the whistleblower incentives.
Yes.
And then you have what you think is a very effective compliance program where
right.
people are trained and they know if they know something, they can report it anonymously so that you find out.
Right.
So, it's just awful when you don't find out. But you mentioned something about incentives to make your own employees use the internal systems.
Right,
We know we have disincentives, because
Right.
if you don't report,
Right.
you're the bad guy.
absolutely.
But how would you work an incentive into the program?
Yeah, I mean, it's tricky, and this is, again, the Dodd-Frank provisions are very new, and so you're finding companies really trying to be innovative now to figure out how to address it. But you could very much offer monetary incentive. If you come forward with an original tip and we had no idea that it was going on, you could offer some sort of a monetary incentive for it. But, you'd be surprised. People aren't all the time driven by money. I know that's contrary to what people believe, but people like to be, recognized. And so doing things as simple as having your CEO do a newsletter and says, Jane Doe did a really wonderful job and she did X, makes a world of a difference to people. So if they feel like they're appreciated, if they feel like what they're doing is beneficial to the company, which again goes to that tone at the top. If you got a CEO that really buys into the process, he or she will want to make sure that the organization is compliant. So if they find out these good stories, encourage them to offer, some type of recognition. Now, sometimes you can't really say, well, Jane Doe told on this organization in Mexico, and as a result, we shut down Mexico, and we fired all those people, so way to go, Jane. You can't do that. But you can certainly be creative in, having the CEO go and meet with her and say, thank you so much. You've been a valuable part of this organization. We really appreciate it. Or, or offer award and say, Jane Doe did something really wonderful from a compliance standpoint, and we just want to take the moment to thank her. Any other questions? So we're all fully educated on FCPA now. Well, thank you all so much for listening. And I think Christine may have my contact information, but I've got some cards up here. So if anyone wants my information, wants to reach out, has any other questions about this, feel free to come and get my information. I'd be happy to email with you. All right, thank you.